Would you be surprised to learn, Mr. Harkness, that the person you just pointed to is not the defendant?
What?
And my client is in the back of the courtroom. Mr. Sakey, would you please stand up?
Objection.
It's not right, but what Saul is banking on is that it's not technically wrong. Is this something that you can do in real life? No. Hi, I'm Jessica Crawford, and I'm a family lawyer in Colorado, and today we are reacting to lawyer scenes in media. Let's get into it.
Unfortunately, we only hire from Harvard, and you not only did not go to Harvard Law School, you haven't even gone to any law school.
What if I told you that I consume knowledge like no one you've ever met and I've actually passed the bar?
I'd say you're full of crap.
Of course, there are some real geniuses out there, but there are very few states that actually allow someone to take the bar exam if they have not gone to law school.
That's a Barbary legal handbook right there, right? Open it up. Read me something. Anything.
Civil liability associated with agency is based on several factors,
Including the deviation of the agent from his path, the reasonable inference of agency on behalf of the plaintiff, and the nature of the damages themselves.
How did you know that?
One thing about going to law school is that you actually do start to learn your rules like that. You're supposed to be able to rattle off those rules in such a way that it's like muscle memory. But the idea that law students do know the rules very well, yeah, that's a pretty standard idea, and it is something that you have to do generally to be able to pass the bar.
Pick a topic.
Stock option backdating.
Although backdating options is legal, violations arise related to disclosures under IRC section 409A.
Well, not if you can find actions to cover up the violation as established in the Sixth Circuit, May 2008.
It's impressive, but you're sitting at a computer.
Playing hearts.
While I love the show Suits, and I do hope that it inspires a lot of people to become lawyers, I just want people to keep in mind that it's not always that easy. There's so much that you have to learn to be able to cross from law school to the actual practice of law.
This isn't elementary school. This is hard work, long hours, high pressure. I need a grown goddamn man.
You give me this, and I will work as hard as it takes to school those Harvard douches and become the best lawyer you have ever seen.
I love his confidence, but is a law firm going to hire somebody who is not licensed? That is a big fat no. He could do some other things, like maybe he could be a paralegal or something like that. I would say that this scene is 0% realistic. You can't go into an interview and talk to a partner like that, just aside from the fact that he's not licensed. I probably wouldn't have carried myself like that in an interview, but hey, if it works for you, it works for you.
We follow orders or people die. It's that simple. Are we clear?
Yes, sir.
Are we clear?
Crystal.
There are sometimes situations where you're dealing with a super smart witness who also may try to intimidate you. And when you're just starting out as a lawyer, that can be so nerve-wracking. Honestly, it feels kind of good to see Tom Cruise in that situation, not just being like, okay, I was the only person who ever dealt with this as a young lawyer.
If you gave an order that Santiago wasn't to be touched, then why would Santiago be in danger?
He was being transferred.
Not what you said. You said he was being transferred because he was in grave danger.
That's correct.
You said he was in danger. I said grave danger. You said, is there
I
any
recall
other...
what I
I
said.
can have the court reporter read back to you.
I know what I said. I don't have to have it read back to me like I'm...
Why the two orders?
In this situation, what that witness's lawyer probably should have done is did some kind of objection, right? Objection badgering the witness, objection asked and answered.
It's somebody else's responsibility to take care of it, right?
Judge, objection. Can we ask the state not to yell at the witness?
That did not happen here, and so that really allowed Tom Cruise's character to just run away with his questioning.
You snotty little bastard.
Your Honor, I'd like to ask for a recess.
I'd like an answer to the question, Judge.
The court will wait for an answer.
Lieutenant Kendrick ordered the code red, didn't he? Because that's what you told Lieutenant Kendrick to do.
Object!
And when it went bad, you cut these guys loose!
Your Honor!
You had
Counsel, I'll
Marcus
hold you
inside
in
a phony
contempt.
transport!
Your Honor!
You doctored the logbook!
Damn it, Kathy!
You coerced the doctor!
Consider yourself in contempt.
You just heard the judge there say, consider yourself in contempt. That is because you really, as a lawyer, cannot sit there and yell at the witness. Badgering a witness can garner you, first of all, an objection. Second of all, it can actually get that witness's testimony stricken from the record. So even if the testimony was great and really helpful to you, it may not be able to be ultimately considered by the jury because of the way that you went about getting it. You can maybe have to pay fines. You could maybe even be put in jail. Also, the judge may even declare a mistrial in the case. And all the hard work that you've done preparing this case, you have to start over.
You want answers? I think I'm entitled.
You want answers!
I want the truth!
You can't handle the truth!
Did you order the code red?
I did the job. Did you order the code red?
You're goddamn right I did!
So that's the moment everyone hopes for, right? Saying something to make a witness admit there on the stand that your case is proven right. That is something that really never happens, unfortunately. As a lawyer, what you're pretty much doing when someone is on the witness stand, you are insinuating all of the reasons why you were right, but it's very rare that the witness will sit up there and say, okay, I'm just gonna hand your case to you just like this. Yes, I killed this person. That is very rare, but it's fun to watch in a movie.
Please, the court, I suggest the members be dismissed so that we can move to an immediate Article 39A session.
I wish that court could go that way sometimes. In real life, court can just be so boring. You're asking the witness questions like, what's your name? Where do you live? Things like that. And those are the things that are never get shown on a movie. I'd say this clip is about 40% realistic. I think that they did a great job of conveying that tension that can be in the courtroom, but obviously they had to dramatize it and make it very theatrical. And ultimately, watching that clip as a kid was one of the reasons why I wanted to be a lawyer today.
You were working at the Sandia Mart the night of the 30th, is that correct?
Got in at noon, left at midnight.
And since the camera system wasn't working at the time, you're the only one who saw the perpetrator.
So what Saul is doing here, it's called a cross-examination. He's asking the witness different questions. You have to ask them in a kind of yes or no format. You have to say things like, so-and-so came into the gas station around 8:30 p.m., right? You had a hard day work, correct? And so it's like you're making these statements and they're supposed to kind of agree with you as it goes on. And cross-examination is so fun because you get to tell the story.
This person came in and they bought something.
I think it was an Almond Joy.
They bought an Almond Joy, and when you rang them up, that's when they snatched the cash from the register. Sounds like it happened pretty fast.
What we're seeing Saul do here is he's kind of starting to testify for the witness. Should you be doing this? No. But you can largely do whatever you want unless opposing counsel objects to it. Sometimes the judge will step in and say, hey, you can't testify on behalf of the witness, but that's where you actually want to make sure that you're hiring a good lawyer who's going to make those objections on your behalf, because Saul is kind of telling this witness's story for him to a certain extent.
But you say you got a good look at him, correct?
Yes.
You must drink stronger coffee than I do, because after 11 hours on the job, I can barely see straight.
Another great trick when you're up on the stand is to really bolster that person's confidence. Oh, you must drink a strong coffee. These kinds of things, really bolstering that person's confidence in their own answers. So that means that eventually he's setting him up to confidently answer wrong down the road.
You feel confident that you can identify this person. That's what you're saying.
I can. Absolutely. It's him.
Are you sure that's the person? There's no doubt in your mind. Take your time.
I don't need time, that's him.
One of the biggest issues that we can see, especially when you're in criminal cases, is people's ability to identify who the actual defendant is. People are frequently not able to remember as well as they think they can. And it actually leads to a huge justice issue. It leads to a lot of stereotyping as well.
Would you be surprised to learn, Mr. Harkness, that the person you just pointed to is not the defendant?
What?
And my client is in the back of the courtroom. Mr. Sakey, would you please stand up?
Objection.
Now, the person you ID'd is named Hollis Early. He's a bartender down in Berlin. He has a very good alibi for the night in question.
Your Honor, objection.
Oh, Mr. Goodman, really?
You didn't recognize him either, Your Honor.
All right, settle down, everybody, settle.
I love that part. There's not a law that says that a defendant must sit right next to their lawyer in the courtroom. And so he banked on that. Is this something that you can do in real life? No. There is something that a lawyer owes to the court, and it is called candor to the tribunal. And that means your representations are supposed to be honest, your insinuations are supposed to be honest. In this situation, there's this kind of bait and switch moment. No, it's not explicitly the wrong thing to do, but ethically, it could get Saul in a lot of trouble. I would say this scene is 30% accurate because I loved Saul's cross-examination. I thought he did an amazing job of it, but that little trick he pulled at the end by not having the defendant sitting next to him, come on.
Would I be accurate if I described your relationship with Mrs. Cole as totally professional? I object, Your Honor, and I move to strike!
Mr. Reed, I don't know what you're on, but you better get to the point and quick.
This might be a moment where a judge would possibly call a recess to see what is going on. Obviously, something is not right with counsel. I would say so far, not very accurate at all.
Is your relationship with my client entirely platonic? Not! Is not your relationship with my client, boink! Bad baby, bad baby. Did you ever not make love? Did you?
Mr. Reed!
You had sex with her every time you met, didn't you? Didn't you? Liar!
He's badgering the witness.
It's his witness.
This is one of those things that may get you worried about being fired on the spot. If you are fired like during a trial or something like that, you often have to end up finishing out the trial. That's just kind of a little tidbit, interesting tidbit for you to know there.
You slammed her, you ducked her donut, you gave her dog a sausage, you stuffed her like a Thanksgiving turkey. All right.
In a situation like this one, Jim Carrey was not meeting his ethical obligation of representing his client. It really seems like he could have ruined her case in that moment. For that reason, I would say that this clip is 0% accurate.
And have you ever served on a jury before?
Twice, both were mistrials.
Twice. Okay.
This process is called jury selection or voir dire. I'm from Texas where we call it voir dire. You're asking them questions to see what their possible position could be as it relates to what your client wants and the outcome that your client wants. So for example, if your client has been a victim in a crash with a big rig, you're going to want to ask questions like, hey, have you ever suffered an injury before? Have you ever been paid for suffering an injury before? You know, things like that, because you're trying to gauge what their ultimate decision may be long term.
How long have you lived in the area, Mr. Tchaikovsky?
About 10 years.
And you run a flower shop.
Yeah, with my wife.
Mr. Robinson, it says here your wife has primary custody of your daughter. Is that correct?
Yeah,
Do you mind if I ask you who ended the marriage?
she did.
Thank you. All you.
Both sides are getting to ask these really important questions, and both sides get to choose a certain number of jurors. You can also do something like striking certain jurors from the pool if you don't think that they will be good for your case.
Have you ever had a physical altercation with a significant other?
Are you going to ask that question to every guy in this courtroom?
If I have to, I will. I know these questions can be very personal.
Nah, man. That ain't me.
You want to be careful about asking certain questions that may offend, right? We saw him ask a question about domestic violence to one of the possible jurors, and we saw that juror get offended, and he felt singled out. That is something that lawyers want to watch out for during the jury selection process, because they want to start to get as many people on their side as possible as early as possible.
You read anything about this case?
No, today's the first I've heard about it.
Well then, I think he will make a perfectly acceptable member of this jury.
This is a really important part of a jury trial. It can kind of set you up to win long term, but also it helps you to create a relationship with the jurors early on in the process.
You're not allowed to investigate the case outside the jury room.
Yeah, I know. But, I mean, somebody's got to. Don't you want to know what really happened?
Yeah, of course.
If you're ever a juror, don't be this juror. You are not supposed to be doing independent investigations of what is being presented to you in court. There are certain reasons why only some evidence can get in. You could be dismissed from the case as a juror if you fail to follow these rules, or you can cause the case to have a mistrial. So do not do this. Do not do your own independent investigations as a juror. This is a big no-no.
You violated your oath as jurors. Mr. Tchaikovsky, you are hereby removed from jury service. On account of your background, I'm going to make an exception and not find you in contempt of court.
Thank you, Your Honor.
Yeah, you can get in big trouble as a juror if you break the rules. So make sure that you are not the juror who is violating these rules. Other ways that people can violate this is to do research online, see what the news outlets are saying, reading the comments, going and checking the people's social media pages. All of those things can be very tempting for jurors to do, but keep in mind that that can really violate just those rules of fairness. And so it's just not okay to do. When you're a juror, make sure that you are following the rules. I would say it's pretty accurate. I would give it a 90 to 100% accuracy.
The statute requires proof that there was some undue influence, someone threatening the residents of Sandpiper Crossing.
As far as I understand it, no one has claimed there's a guy with a knife telling them to hand over their lunch money.
So this scene seems to depict some type of mediation between the parties. One thing is mediation actually looks a lot different from this these days. Mediation usually just happens on Zoom. The people are not in front of each other, or they're often in separate rooms so that the lawyers can learn more information from their clients.
Some of your clients have, in fact, been overbilled. It's an accounting error. It doesn't rise to the level of fraud, not even close.
We've calculated the damages. All told, it's $46,320.
So when people think of lawyers, they think of court, but that is just not always how it works. Most cases actually go to mediation first. Most cases actually have people negotiating for a long time, all the way up until trial. I've had cases settle on the courtroom steps. So remember that.
A check for the 46 and change right now. And on top of that, we'll give you another $46K to cover your expenses. So what's that, 92? Let's call it $100,000 even. We admit to no wrongdoing, and your clients release all claims.
I think you're gonna need to do better than that.
When it does come to negotiating or making a settlement offer, yeah, you will often see people come to lowball you at the beginning, but I do think that it is important to hold your ground in certain circumstances. For example, on Saul's side, they knew that they had some really amazing facts that could substantially increase the amount of money that they were going to get.
You're looking at treble damages, so your 100 grand, I think you know where you can stick it.
What number exactly did you have in mind?
20 million.
Excuse me?
You heard me.
Oh, you can't
$20 million. Or we'll see you in court.
I would say that this clip is 70% accurate. As a lawyer, you always have to convey settlement offers to your client. But there are certain circumstances where your client may give you a threshold of things that you are allowed to approve. That may have been something that happened here, but it's very likely here that the client only approved up to $100,000, because when that lawyer heard that $20 million number, he immediately balked at it. That does not sound like a number that he wants to take to his client.
A statement, my lord, which vindicates all of these people, all these innocent
My lord,
people.
I need
but
to see a copy of this
someone,
statement.
either that man or his superior or his superior's superior, ordered that these people be used as scapegoats by a nation that was baying for blood.
My lord!
In return for the innocent blood spilled on the streets of Guildford. And by God, you've got your blood.
Okay, it looks like she pulled out some evidence that had not been submitted to anyone in the courtroom prior to this outburst. Can that work? Really, you have to disclose evidence far before the trial actually takes place. If there is other relevant evidence that comes up in between that actual deadline to submit your evidence to the court, then there are some other things that you can do to maybe get that evidence in. You can get it in as a rebuttal, which would mean you would need multiple copies of it, and you would ask the witness certain things to see if they lie, basically. If they lie, then you can use this evidence as rebuttal evidence to say, well, I have a document here that essentially is going against what you're saying.
This is outrageous. You've got the blood of Giuseppe Conlon, you've got the lifeblood of Carol Richardson, and you've got 15 years of blood and sweat and pain from my client, whose only crime was that he was bloody well Irish.
While this is a powerful moment in a movie, this is not something that could happen the same way in the courts. Perhaps she was trying to cause some kind of mistrial. Maybe she could get that outcome in the real world, but this is not a good thing to do in court.
My lord, this document brings the entire British legal system into disrepute.
My lord, this is new evidence. It is shocking new evidence. My lord, this evidence was not submitted at the trial. It is under appeal.
I would say that this clip is about 20% accurate. As a lawyer, you can't just stand up in the middle of the courtroom, yell at the witness, yell at the judge that you are correct. That is not what you're doing as a lawyer. You have to cover all of your bases, you have to ask the right questions, and you have to wait for a court order. And doing it this way can get you in a lot of trouble, and it can negatively impact your clients. We see shows like Better Call Saul or movies like A Few Good Men that have it a little bit closer to what we may expect to happen in a courtroom or in a lawyer's life or in the negotiation process. And then all the way on the other side, we have folks like Jim Carrey. We would not see those things happen in the courtroom at all. Overall, do I think that the media gets it right? Maybe about 40% of the time, but the other 60% sure is interesting to watch.